Good afternoon, and thank you for joining us today. We often speak about intellectual property or IP as a tool for innovation and growth. But today, we will look at a real case where a lack of understanding of IP led to a series of poor decisions. As you can imagine, the result was a significant waste of time and resources. There is a lot we can learn from situations like this. So we thought we could all benefit from these stories. My name is Claudia Tapia. I'm the president of 4IP Council, and I will be your host today. 4IP Council develops robust empirical research and academic insights on policy, invention, innovation, and IP. Today, I have the pleasure to moderate this session, IP Gone Wrong, What to Do Differently. This webinar is co-hosted by the EUIPO, which is the European Union Intellectual Property Office, responsible for managing EU trademarks and EU designs. Our distinguished experts are Claus, Heide, Andersen, and Tim Becker, both from Eurojuris, as well as Lisa Jefferiss from EUIPO. We will begin with a conversation with panelists, followed by a Q&A. Please feel free to submit your questions at any time using the Q&A tool at the bottom of your screen. Before we begin, Lisa, would you like to share a few opening remarks from EUIPO?
Yes, thank you very much, Claudia. And thank you for letting us join you here today. It's a real pleasure to be here with you and to have the opportunity also to contribute to this session. I'm really looking forward to hearing from Claus and from Tim and from their experiences. As for me, seeing intellectual property in practice is particularly within the real business context is particularly valuable. It's what helps us bridge the gap a little bit between the theory and the reality and brings to life the real impact that intellectual property can have on companies. So thank you for allowing us to be here with you today, and thank you to everybody who has joined.
So true. Thank you so much, Lisa. It's a real pleasure to have you with us today. And I'm going to move now to Claus. I understand you will be sharing a case about a medium-sized company selling electrical appliances, and that we will call it Oasis, although that's obviously not its real name, correct?
That is correct, Claudia. And first of all, I'd like to thank you and also the 4IP Council and the EUIPO for the invitation. I'm really happy to be here today. The case that we are going to talk about is indeed with the company that we call Oasis for confidentiality purposes. It's a medium-sized company that is not only producing electrical appliances, but also inventing electrical appliances. They have a quite substantial research department, and a few years ago, they made some new improvements to one of their existing products. It ended up with a new feature that was included in the product, and we will call the new feature QuickSync, which was also the name that the company decided to use to distinguish the new product from the existing product. As I mentioned, the company is actually quite innovative, so they thought they were quite good at IP rights, and they also applied for a patent for the new technical features that were included in the product, but they did not apply for the trademark QuickSync simply because they believed they could not trademark it.
Oh, wow, interesting. So let me see if I got it right. It's like a car company inventing a feature that can detect danger around corners or see far beyond the driver's line of sight, and that's in that example the company gives a car the name of Beyond Sight to highlight the feature, but does not protect that name as a trademark.
That is correct. Well, they didn't consult the lawyer when they actually made the invention, and they actually thought that the patent will be sufficient protection, because the real innovation was not the name itself, it was actually the technical feature. So they did not think that there was need to register the trademark QuickSync. However, what the company failed to see is that a patent will stop competitors for using the technical innovation, but it does not stop competitors for using the trademark. So if the competitor decided to copy the Quicksync product simply by copying the technical side inside the product, they could stop it easily with the patent. However, if a competitor decided to use the Quicksync name and use a different technology that is not patented inside the product, then it will be much more difficult for the company to actually stop competitors for using Quicksync.
So it seems they were confused about the purposes of the patent protection and trademark protection. Tim, what are your thoughts on this?
Well, first of all, hello to everyone. Thanks for having me. Well, yes, indeed. One could say that they kind of confused patent and trademark protection. And one has to bear in mind that patent protection seeks to protect a certain technical invention, so a solution for a technical problem, meaning how something works, whereas the trademark protects the name of the brand of a product of a service. And obviously, in this case, I'd say that yeah, the company thought that they would have a certain protection because in their mind, Quicksync was linked to the technical product, but they didn't make a distinction between trademark and patent.
So the company assumed that its patent will stop competitors from using the same name, and in other words, it confused protection again from what is protecting the technology from protecting the brand, and they thought that, or they assumed that one will automatically cover the other. And imagine this not go as they planned, Claus?
No, it exactly did not go as planned at all.
Mm.
Competitors actually started manufacturing an inferior product, not using the technology, but using the brand Quicksync instead.
Well, let's see. And what happens next?
Well, Quicksync actually showed up to be a really good product in the home market, and it was a huge success. So Oasis decided at one point they wanted to sell the product on other markets in other EU countries. However, at that point, some of Oasis's competitors had already registered the Quicksync trademark in the other countries. And they started to sell similar products to Quicksync, but with an inferior quality in the other markets. And you can imagine what kind of legal fight that will start.
This sounds really terrible. A competitor was able to stop the company who created the new feature just because they did not register its trademark. And at that moment, what were the options for Oasis?
Well, Oasis had two options actually. They could either rebrand the product completely and start over, marketing the new product in the home market again, all over, or they could decide to fight in all the jurisdictions where they want to sell the Quicksync product.
Well, none of them appears to be an ideal solution. What did Oasis decide to do?
Well, actually, they decided to fight. It easily proved that they have used the Quicksync trademark in the home country. So that was actually quite easy for them to establish their right, especially because the founder of the company, which is an old engineer, had saved all marketing material used over the entire time of the company. So he had a scrapbook with all marketing material showing the proof of use, and he even collected third-party advertisement in other countries as well, because he was actually quite proud of his product and his company. So in the home market, it was actually quite easy for the company to win the right. However, in the other jurisdictions, the fight was a bit more mixed. It depended on what kind of trademark that was registered and also how they could prove use. However, the company were quite successful in proving that the trademarks registered by the competitors has been registered in bad faith. However, after a long legal dispute in many countries, the company was actually partly successful in obtaining the right to use the Quicksync name. However, they didn't get an exclusive right to use it, so they had to share it with competitors in most markets.
Claus, this sounds like painful and costly process. And I can only think this could have been avoided.
Well, it could have been avoided easily, actually, if the company has just registered the trademark from the beginning. So they will have had the exclusive right to use the QuickSync name, not only in their own jurisdictions, but also in the other jurisdiction where they potentially might have want to sell the product.
So that means that with a trademark, nobody else would have been entitled to use, in this case, QuickSync. But this for a product in the same business area. And I just think that this case offers so many lessons. Claus mentioned that the company had two main options, which is rebranding or litigate, and that they chose litigate. What are the pros and the cons of rebranding?
Rebranding means, first of all, that that you reduce the risk of a litigation procedure, meaning that you do not have to have all the costs of such a procedure. Rebranding also could lead to a certain settlement in climate with your competitor when he sees that you are ready to go a different way. And you may also, by rebranding, correct earlier mistakes you did in your setup of your marketing strategy. And also the rebranding could lead to certain evolution of the brand. We all know that from time to time brands are refreshed in a certain way. When it comes to the cons, you have to bear in mind that a rebranding can be also very costful. So you have to take into consideration that this might be even more costful than going into the litigation. And you may also lose some of your brand recognition. And finally, you may also risk a second conflict, because using a new brand always bears the risk of a conflict. And you may, if you do not go far away enough from the existing trademark, also face a conflict with your opponent.
Wow. So indeed, and I wonder, because again, we had these two options, but what about litigation? What were the risks of going into litigation in several jurisdictions?
Well, litigation is pretty much the other side of the medal in this case. So it's also a question of costs, especially when you have to go to several jurisdictions. And it also means that you have an uncertainty about how long the whole procedure will last, and what is the outcome of the whole thing. Also, the litigation procedure could do some damage to your reputation. And yeah, finally, if you go to different jurisdictions, you may also face that you have a different outcome in different countries. And if you're very successful in a lot of countries, but you stay with a problem in one, this may lead to the result that you also have to rebrand.
Wow. So if everyone in the audience has built their own business and is listening to this case, I bet you can relate to the pain behind the situation. We've learned, I think, with this case about the consequences of getting IP strategy wrong, like loss of exclusivity, legal disputes. We talk about the significant cost, business uncertainty. And I cannot think more than that. You know, the next question for me is, how can companies prevent these problems, kind of prevent them and make sure that they don't happen? And Lisa, if a company like this one came to you early on, what kind of support or guidance could EUIPO offer to help them avoid this situation?
Thank you, Claudia. Yes, indeed, they got themselves into a bit of a situation. I think Claus mentioned already at the beginning when he started speaking that what could have solved the issue was talking to a legal representative early on. No? So speaking to someone early on in the situation could have alleviated the problem. Here at the EUIPO, we don't offer direct advice to applicants, but we do put in their hands a range of tools and services that can support them along their IP journey. One of those in this particular case that I think would have been interesting for Oasis with the QuickSync issue would have been the pro bono service. The pro bono service, you can find information available on the EUIPO website if you're searching for pro bono. I believe we'll share also some information following the session. But what it is, it's basically we carry out a matchmaking service between companies and IP experts. So the EUIPO isn't offering the guidance itself, but rather a company can apply for the service on our website, fill in an application form with some basic details, advise of the area of support that they're looking for. The most common is support in completing a trademark application. This is the most common, but it gives a bit of an idea of the types of services that are available. And from there, we do a matching with the IP experts who have volunteered their time to participate in this service, who are able to offer support in that area. And we share then these contacts with the company who can get directly in touch with the IP expert.
That's great. And by the way, we're gonna share links later on in the Q&A so that you can have them, and we will also post them for IP Council. And at the beginning, we heard about look for legal support, and you also mentioned you do not provide this legal support in the sense of advice, but you do help in terms of tools and services. And what I hear very often when I mention look for a lawyer from the beginning is that many small and medium-sized enterprises are worried about the cost of protecting their IP. Could you briefly explain how the SME Fund 2026 can support companies in registering trademarks and other IP rights?
Of course, yeah. So financial difficulties are faced by many companies, especially when they're starting up now. Money is tight, you're investing in many areas as well as the intellectual property at the same time. So it can be difficult to find funds for everything. So what we have is we have the SME Fund, which we run in collaboration with the European Commission. And that is a way to alleviate a little bit the costs for small and medium-sized enterprises in protecting their intellectual property. So it offers reimbursements for trademark applications and trademarks. Sorry, I said trademarks, but I mean intellectual property applications and trademarks, designs, patents, and also plant varieties, up to 75% of a reimbursement, and also support services like IP scan in certain countries, up to 90% of reimbursement. What this can mean in terms of the financial implication, because it's all very well saying 75%, but what is that? So for a European Union trademark, for example, which would be a trademark that would cover the entire EU, so all of the countries within the EU would be fall under that, which would normally cost 850 euros. The final cost for the applicant would be 212 euros 50 cents. So you can see a bit there in practice what that means. One important thing that I should highlight, because we always get questions on this, so anticipating any potential question, is the process. So if you have already applied for a trademark, a patent, or a design, it's not possible to request the reimbursement for the fund. But the process would be requesting the SME fund, so requesting the grant through the fund. And then once you receive a positive reply, make the application for the trademark, design, patent, or plant variety there, and then request the reimbursement. Okay, so you would do the fund first, then the application, and then we got the reimbursement.
Wow, thanks for making it so clear for us to understand, and it's really truly impressive. And I agree with you. The best way is by seeing examples how this will work in practice. In a case like this, an early IP assessment could have made a difference, a huge difference. And you mentioned before the IP scan. Could you explain what an IP scan is and how it helps this scan companies make better decisions from the start?
Yes. So an IP scan, what it looks at is intellectual property within the context of a business. So many people perhaps think of their intellectual property as a means to have it protected in where they are operating, but not look any further, but mainly for competitors not to move in on their innovation. But IP scan puts it more into the business context as well to see what benefits the intellectual property can bring you. So it goes through your business journey a little bit, seeing where IP fits in, checking that, well, it can also help identify types of IP that a company might not even have realized that they have. but also to check that they've got the right level of protection if they are operating nationally, European, internationally, but also help guide them in their journey in their future. So if they're operating nationally but looking to go at a more European level, it can give some guidance there, and also some implications on how to make use of their IP, so through monetization, through licensing, franchising, anything that they should be taking into account or aware of there. There are different models of IP scan. So I've just described briefly what it is, but how can you do one, no? We have an IP scan online tool on the IP Support for Business website. This is I would say, a brief introduction to what an IP scan is. It takes around 20 to 40 minutes, and it gives some indications on what IP a company may have registered and what the next steps could be or what to look out for. So if they're looking to expand. But a more in-depth IP scan, which is the one I'd mentioned previously in the context of the SME fund, is available as well. And that means sitting down with an expert who will, I believe they start with a questionnaire to get some basic information from a company. And then from there, they'll go through all of the information with the company to make sure it's all understood and kind of guide them through where IP is fitting in their business. This model, important to say, because I mentioned it in the fund, is available in certain countries for reimbursement under the SME fund, and the company can be reimbursed up to 1,620 euros. But I say it's only some countries, but if you do go on our website and you're interested in IP scan and you see that it's not available in your country, it might be worthwhile also to contact the National Intellectual Property Office. Because in many instances, it's not available in some countries, but it's because the National IP Office is actually running their own similar scheme. So if you go on our website and see it's not there, contact your National IP Office, because you never know, it might be available.
Very good. I think now we have a plan. And it seems that prevention is really the common thread here, like seek advice early, build an IP strategy, use the available support, funding before launching the product. Claus, if someone in the audience has a new product name in mind, what is the first practical step they should take before launching it?
Well, first of all, I will advise the company to make a clear IP strategy, and of course to register the trademark. And also not only look into registering your own rights, but also make sure that you don't infringe on other third-party rights so that you have the freedom to operate.
Thank you, Claus. And I was thinking, Lisa, you were talking before about tools. Are there tools available that companies can use themselves to check whether a name is already registered?
Yes, so we do have a dedicated tool for that. There's tools for many things, but there's also a tool for that. It's the TM View, standing for Trademark View tool. This tool is something that companies can use, users can use to check if there is already registered a name that they are looking to register. It's very user-friendly. You simply type in the term you're trying to search for, and it comes up with the results if it's already registered, in which business area that it's registered, into which goods and services, to know if there's a conflict or not, in which country it's registered as well, is also of interest, mentioning countries. The information that we do have in the TM View tool comes from all of the EU national databases. So all EU databases are covered in terms of trademarks, so anything registered within the EU at a national level or at the EUIPO are covered, but also a range of international databases as well. So we have a lot of beyond the EU information incorporated as well in the tool. So it's very interesting and very complete. So if you do see it, if you are using the TM View tool and you find some results that you're not sure about, if you think maybe you would be infringing on something already existing, it could be also a good time to reach out to the pro bono service.
Who has access to the tool that you mentioned before? Is it just for legal professionals?
No, it's available to everybody. So it's fully accessible to the general public. And as I said, it's very user friendly, so designed so that most people can fully understand what's there. It's multilingual as well, and the data is continuously updated. So the data that you'll find in there is very up to date and very complete. So it's a very trustworthy tool.
So it seems that choosing and protecting a name is key, but registration is at the end only part of the picture, right? So the way somehow you define the scope of that protection is equally important. That's at least my view. And Tim, I understand you've brought another case today. Can you briefly tell us what happened?
Yes, certainly. So in my case, a company launched accommodation booking app, which quite soon became very successful. And they also registered for European Union trademark, but kind of forgot to include the app's core booking and reservation services, and just focused on some future services and products they weren't even offering at that time.
So that sounds like a costly mistake. What happened?
Well, the thing was that they relied on an earlier international trademark relation where these core services were already covered. But unfortunately, this registration later failed, and so this left a very important gap in the protection.
Wow, but you also mentioned they were very successful using the app. Wasn't that enough?
No, unfortunately not, because at a later stage, a competitor challenged the trademark, and the company had to prove genuine use of the products and services they were claiming protection for. And unfortunately, the company could not show sufficient evidence in this case, yes.
Seems that evidence is always key in this part of the process. And how did the court decide? What did they decide?
Well, the court found that well, the trademark protection was not lasting very long, so the court restricted the trademark to very few goods and services for which the company could prove genuine use for, and so in the end, the company lost protection for most of the services, and especially for the ones that mattered the most for them.
Tim, Claus, when I'm hearing all this, I imagine that on the positive side, from those who are joining, there's a lot of key lessons learned regarding IP strategy for business. Maybe, Tim, would you like to start?
Well, yes. First of all, I'd say it's very important to cover your core business activities, because that's the most important thing when you register a trademark. And also, you should make sure that you regularly review your trademark portfolio and the products and services you're actually offering, because this should be aligned. And of course, you should rather focus on your core products and services instead of having a very long list of things you never use.
Exactly, Tim. And I would also say that you shouldn't rely on assumptions or pending applications. And if the business evolves or an earlier registration fails, you should always look into your IP strategy and move along accordingly. So you take action as soon as possible. And I would say that well-targeted trademark registration together with genuine use is often far more valuable than a just broad registration of a trademark.
Important. Thank you so much to both of you. We have someone in the audience who is asking regarding registration in bad faith by third parties. What can you tell us about this? What do you do suddenly if a third party registered? And I imagine they can register only if you haven't registered. So thoughts? Who would like to take this question?
Well, I would go, and I'd say that first of all, you need to explain a little bit what is this bad faith registration. This happens when someone has an improper purpose in registering a trademark. So usually this aims at blocking someone else in entering into a market, or maybe just extract some payment out of this trademark registration. One of the most frequent cases is that you have a commercial agent acting for a company in a certain country, and when this relationship breaks up, then the agent tries to register for the trademark just to get money out of this, or to protect himself against the entering of the company into this country. And so you can say that the bad faith registration always means that you have some dishonest intention. And the problem with bad faith registration is that you have to give evidence, or to have really promised to prove that someone registered a trademark in bad faith, because there's kind of a presumption of good faith when you register a trademark. So you have to find difficult points where you can say that they are indicating the bad faith registration, such as you already knew the earlier trademark at the date of filing the new registration, and also if the whole setup of your business is more or less a copy of what the trademark holder in the other country is already having. And it's also that if you ask very quick for money, and you get the feeling that someone only wants to get his gain out of this thing, this could also be one of those points you would focus on. But generally said, it's not so easy to prove bad faith.
It sounds like it's really not. I don't know, Claus, Lisa, whether you have any additional remarks. Otherwise, we can move to the next one.
No, I'm actually agreeing with what Tim said.
We all agree with Tim then. Great points. And I see here, Lisa, there's a question for you. And I remind everyone you have the Q&A button in the lower part of the screen in case that you want to raise more questions. Lisa, can an SME request the fund if they have already applied for a trademark, patent, or design?
Thank you, Claudia. This is a question we get frequently, and I'm afraid the answer is no. So it's not for applications that have already been made. First, they would need to request the SME fund, and then thereafter make the application for the trademark, the design, the patent. So first would be requesting through the fund, and then going to request make the application.
Okay, that's important. Thanks for clarifying, and also thank you for the question. And here, Claus, in the first case, for a while, the competitor was selling products using the name, the same brand, the same brand, but of an inferior quality, if I understood it correctly. And I wonder about the impact for consumers.
Well, first of all, the impact for consumers is that when you buy something of an inferior quality, of course, you don't get a product that is as good as the original product. It also, in this case, with QuickSync, it promised something in the name that the inferior product couldn't actually deliver. So consumers were actually, I would say, cheated into buying a product that was of a worse quality than the original product, and it couldn't live up to the promises it made.
So one built the reputation, and the other basically still that and mislead the consumers. It's kind of tragical after the whole work and effort that comes into building something like that. Tragic. Yeah. Back to Tim. Why was the founder's documentation evidence so important in the case? And I think we're talking more about the first case, right?
Well, in any case, the evidence of using the trademark is very important, because you have to bear in mind that a trademark gives you a certain exclusivity. So you're the only one to use the name or the brand for the goods and services you have registered for. And the economical view behind it is that someone should not be able to block others from using a trademark when you don't use it yourself. And that leads to the situation that in the beginning, for the first years, you have a certain grace period of use. So during this grace period of 5 years, you do not have to give evidence. But after those 5 years, you usually should start giving, or should be able to give evidence that you really used your trademark. And it's it's very important that you can show that you use the trademark for the products and services. And from this point, you should. We again at this thing that you should not register a trademark too large, because it doesn't help you at all after a certain while.
The issue of scope is important. Maybe could you elaborate on that? How narrow? What are the benefits of having a broad scope versus a narrow scope?
Well, you're asking me?
Yeah.
Yeah. Well, the broader scope gives you better protection in the beginning, so you may be able to get competitors keep away from your area of business. But after the first period, then you get into trouble if you cannot show the genuine use of the goods and services. So you should always bear in mind that you focus on what you really are doing, because otherwise you may lose the whole of your trademark or the most important parts, which would not have been the case if you just sort of protected and focused on your core business activities.
Thanks for clarifying. I think it's an important part, which might be obvious for those who are involved in IP, but it's not always clear for those who are applying for it. And we have received also another question, which I'm going to read, and it says, if there's a trademark registered in 2008 and in 2014, there is a geographical indication with similar name. So 2008, we have the trademark registered, 2014, the geographical indication, and the geographical indication has a similar name, which has applied for the registration. Will it make the trademark registration invalid?
If I understood the question correctly, then it means that you have an early trademark, and then later off there's a geographical indication, if that makes the trademark invalid.
Exactly, and the geographical indication has a similar name than the trademark registered before. That's
actually a good question. I'm not quite sure if I can answer that straight away, to be honest. However, my assumption would be that the trademark would be, as an earlier right, probably would be invalidated, or you might have to go into the discussion about the geographical indication if that's actually a right way to do it. But from my assumption is that the geographical indication will be the strongest right. I'm not sure if you agree, Tim.
Well, I do, but I also share that I wouldn't answer this out of the pocket. Seems to be a very complicated question. Yes.
Yeah, and I want to remind everyone this is not a legal advice session, but rather to give you enough information to see what to do. And if you have a specific case, I strongly recommend you look at professionals, so that someone like Claus or Tim, that they can analyze the concrete case and give you a legal advice afterwards. And I have here a question for Lisa, which is, how long does protection last for trademark and patents?
Okay, yes. So the time frame for different IP rights varies depending on the right, so it does change. So it's a good question to keep in mind as well for the IP strategy when you need to renew, because one thing is when you make your application, you have your trademark, you have your patent, but you also need to consider also renewals. So in the case of trademarks, for example, you can receive unlimited protection, provided that you are renewing every 10 years. So you need to bear that in mind as well, that one thing is to have the protection, but then you need to also be careful and make sure that you're on top of the dates to make sure that you're renewing it on time. In the case of designs, it's up to 25 years, renewed every 5 years. It was patents, no, that you'd asked about?
Yeah, patents and trademarks.
Patents and trademarks. Yeah. So patents, the time span is for 20 years, but there's no possibility to renew. So after 20 years, then there's no possibility of renewal. So it's an interesting question, but again, bear in mind also to remember to renew. So once you have the protection, it's not that it's for lifetime. You need to also make sure that you're keeping on top of the IP strategy and making sure that you're renewing.
Perfect. I'm going to go with the next question. which is regarding a commercial team which launched a new product with a brand and logo they made, but the team did not check before the availability of a trademark with the legal team. So this means that there is no trademark registered yet. And the question is, what's the best way to handle this, considering the product was recently launched and did not have much traction yet?
Well, I'd say that's a very typical situation because lawyers sometimes are just felt to be, well, the problem in on the track to the market. And nevertheless, I'd say don't just go ahead, but check on all the legal background for this new product or new product name, because you should at least be able to check on the risks you have, and also to decide whether you can still register a trademark, which usually you should be able to do so, because running into a conflict at a later stage could mean that you have a lot of higher costs in rebranding and all those other things. So I would also always recommend to immediately check on all the legal problems that may arise, and then take a decision on whether to seek for your own trademark, whether to just continue, or maybe if you find earlier trademarks that are obviously infringed, to start the rebranding immediately, also to keep the cost low.
Yeah, very important. Thanks for clarifying. I think I'd like to explain also, or one of you, whoever wants to take it, maybe Claus has been silent last time. What should companies, or what do they need to understand regarding descriptive names and trademarks?
Yeah, well, I think first we need to talk a bit about what a descriptive name is. And that's when, the trademark is actually something that describes the product or the service that the trademark is supposed to cover. And it's a general rule that you cannot register a trademark that is descriptive for the product and service. So as an example, if you have fruits, then you cannot register the trademark apple, because that will be a descriptive for the product group of fruits. Whereas I guess we all know that Apple as a computer is not descriptive for a computer itself, so that could be registered as a trademark. I think that's a simple example on what to do. So when you come up with a brand name, and when you do your brainstorming in the business, look for something that is really one of a kind. Don't try to use something that is generic or descriptive, because it's not impossible to have it trademarked in a way where you brand it so much that it become your trademark. However, it's much easier to deal with some new word that has been invented. Maybe where you take two words and combine them and things like that, and that will even make your brand stronger from a business perspective, because it will be more significant.
Thank you. How could early IP advice have changed the outcome?
I don't know if I should start, but in the first case, if the company has registered the trademark from the beginning, it will have been so much easier for the company. That would have saved a lot of costs, because I know it cost a bit of money to register the trademark, but that's nothing compared to the cost that the company incurred fighting in all the jurisdictions. And I would even say, if you're in doubt about two names and you want to test them, well, register both trademarks in the beginning, because the cost for registering a trademark is actually quite low. And you may always give it up if you don't use it, or you can deregister it again. So there's no need to keep it. But if you have like two names you want to use, register both. So make the registration early on. And also another really important thing is that when you start using the trademark, gather all evidence that you have. That could be either marketing material, copies of home pages, posts on social medias, everything that you can get where you have marketing for the trademark. it's a great help when you at a later point have to either enforce your right or to prove that you have used the right.
Thank you. Tim, any ideas?
Well, yeah, well, I agree with Claus, and I'd also say, if the companies in our cases would have seek the advice of a lawyer before, or of someone who's familiar with trademark rights. Well, the first question or the first question I would raise when someone tells me, well, I'm here and we have IP protection, I would not let them go, but ask, what kind of IP protection do you have? And if they come back with me and say, well, we have a patent protection and we're talking about brands or names, then yeah, I would immediately recommend to seek for registration. So that's for sure. And in the second case, in my case, it was obvious that it was not a very good idea to leave out the core business activities just because you thought that they were covered by an earlier trademark registration. Because checking on the earlier trademark registration would have shown that the registration was not finished yet. And even if the international trademark would have been registered, I would have recommended that the second trademark also would include the core competences, because you never know whether a trademark, well, it can be kept for all the times. So yeah, I think in both cases, IP advice would have been recommendable.
Definitely. And you were mentioning about the importance of registering, the importance of gathering evidence, because I think at least we saw in the first case that's play a key role, and in the second case they didn't have enough evidence, so also a key role. It's not the ideal first advice and registration. We also have seen EUIPO having tools that you could use yourself, some quite easy to access. And I would say from previous events and what we have seen this happening, that the tools have been used and that have made big differences for companies. So I really, really encourage you to use them. We were mentioning about these steps on IP management, and we cover a lot in terms of mistakes made and what would have been if they have got legal advice from the beginning. And I wonder, is there any other additional advice or any common mistake that we haven't covered today that you will say, please, please, please pay attention, because this happens quite often, and now is an opportunity for all of us to learn about it.
I think from our side, the main one. Oh, sorry.
Lisa, you go.
I think from our side, the main one we hear is the one that was covered, but also in the question, about I've already started using my project name, but I haven't done any checks. And we hear time and time again. So I think as well, that's been the message through some of the case studies that we've seen, but not just register, but also make sure you do the checks, not just for yourself to see if it's, but to see that you're not infringing on somebody else's work, because this also we see when we speak with some companies, we ask them, are they checking if other people are infringing on their work? And the key question we ask is, well, are you checking you're not infringing on somebody else's? And normally the answer is no. So I think this is a key takeaway as well that we should bear in mind. We've seen it with the case studies, but also with the questions asked, but it comes up time and time again.
Thank you, Sam.
I think we have nowadays so many ways of getting information, and if you go to the website of the EUIPO, I think they provide so many information and tools to get closer to the topic, even if you have never registered a trademark. But I think it's a good approach to first see what you can get in information from the website and all the tools they offer, and then afterwards you have a lot more of an idea of where problems could raise. So yeah, I can really recommend to do so. Yeah.
Thank you.
If I should add something, I would say that I would encourage companies to treat IP a bit more seriously than they do. Like any other assets that the company have, that it needs to be protected, and it also needs to be maintained, like if you have a building or if you have a computer. So make sure that the IP rights that the company has is well maintained, because it might prove actually quite valuable for the companies.
Thank you. You know, I'm thinking, like, in every profession, you're going to find people who are super competent and others who aren't. Imagine now I'm a startup and I want to find legal advice. Where do I find the right people? What do they need to have for you to be able to obtain a good advice? Because it's equally disastrous to not have any than having a bad advice and then file a wrong scope, not covering enough. Do you have any tips, any ideas that you could share?
I would say to lean on trusted services. So those that we've presented today, we have the pro bono service. We have also an IP scan service. So here we're dealing with IP experts. So if you're not sure where to go in a first phase, these can be first points of contact, but they can also be recurring points of contact. So we see with the pro bono as well that it's in a first phase that may be someone you can contact, but moving forward as you develop your company, if you need further legal advice, you can also go back then to the same person, no? Obviously not through the pro bono service, but then you've made a first contact with an IP expert in that field. So I would say to go with the trusted services that you can find, and also put IP as part of the business strategy. So don't deal with them as two separate things. IP is part of the business. And also when you're talking with these experts, they can also give you advice on how to make the IP work for you. So how you can actually make best use from your IP.
Indeed. Any other advice from you, Claus, Dita, Tim, in terms of what you think it's important to be able to advise?
No, I would actually recommend that if a company is in need of an advisor, go to the pro bono side of the EUIPO that Lisa just mentioned, because then you will get a local somebody speaking your language, knowing your local rules and how to operate, and it's actually quite flame-free, I would say. So it's a good advice to start there at least.
Very good.
And maybe to mention, if you got the feeling that something is wrong or that you could get into trouble, then follow this feeling. A lot of people intend to say, well, yeah, I know there might be a problem, but as long as nobody is raising this, we will leave it behind, and it will there will be a solution for this someday. And IP problems usually do not get better when they're longer in the world.
No, we have seen today all that can happen if they don't think about IP from the beginning. And I think what we have learned today is about all the opportunities also that startups can have, companies starting in the business when they have an idea, how to protect it, how the EUIPO is having all these amazing tools and services. Also the possibilities for yourself to have like a quick searches from the beginning, and this possibility of expanding and making it, as you said, this IP is part of your business. At For Council, we also put a lot of effort in bringing these messages, the link between intellectual property and innovation. We have also a section for small and medium-sized enterprises to be able to translate the difficult IP messages into easy to digest messages, and can offer tools like the ones that Lisa has been mentioning. We have webinars, we have also on the website different links so that you can go there. And one of the next projects we have is to have a link on IPR management. So I hope with that we can support in this path of the startups and SMEs that are building amazing technologies and ideas, and we want them to succeed. And listening to both examples, one thing really stands out to me And in the first case, we saw the company didn't protect its brand. And in the second, it had a trademark, but hadn't protected the part of the business that mattered the most. And these are kind of different mistakes, but they both ended up creating expensive problems that could have been avoided. And I think we've learned also today that innovation systems work best when companies understand how to use IP effectively. Many challenges we see in practice are not due to the system itself, that there's a problem in the system, but rather that they are misunderstandings about how the system operates. And this is why the webinars like this one today are, in my view, crucial. So I'd like to thank very much Claus, team, and Lisa for sharing your knowledge and expertise. And I also like to thank you, all of you, for attending this webinar. And remind everyone the recording will be made available at 4IP Council's website tomorrow. And finally, also another kind reminder, which is that tomorrow you will be receiving an email. And in that email, we will invite you to complete a 1 minute, just 1 minute survey about this webinar. And we would be very thankful if you could send us your feedback, because this is what allows us to improve, and we also can have lessons learned. Thanks again, everyone, and good luck to all of you.